Good afternoon, ladies and gentlemen, or morning, depending on where you're at in the world. Welcome to Burn the Corporate Fiction, where we take complex subjects in law and secrets that have been occulted to you and explain them simply in a way that people can easily understand, because we all know that the lawyers like to obfuscate the definitions of things and never even teach law in school or anything like that. So, I mean, that's the funny thing. They say ignorance of the law is no excuse for breaking it. Then why don't you teach the law in public school, right? Why don't you ensure that people understand these fundamental concepts in law? Oh, because then they would figure out how you've enslaved them. So that's what we're going to get into today. We're going to talk about the impending digital IDs. Texas just issued or enacted a bill that forces people to get a basically a online ID, which is just one step towards digital ID, in order to use Google and Apple products. So we're going to cover that. But primarily, I want to cover the importance of why we need to resist this, is because people know the term straw man. Okay. I hate that term. It's been played out. Cops, it triggers cops to automatically think you're a sovereign citizen and all that if you say straw man. But the concept is very real. It's actually called legal fiction, or ens legis, a creature of law, right? Straw man is just the way that people commonly understand this. And it is the product of a trust, right? So that's what I'm going to start with this morning, is explaining a very fundamental and necessary fact that one needs to know when studying law. That man does not create law. Man cannot create law. Man merely discovers, observes, studies, and applies law to society. But the fundamental law, we did not create. And since all men and women are equal before the Almighty, no one man has the right to subject another man to his will, except under certain circumstances. This is all outlined in the Bible, and it is an ancient understanding in law. In fact, all the way up to about 200 years ago, it was common knowledge amongst students of the law. And I'm going to show you that in a couple of treatises this morning. So, and then we're going to get into the current events. You know, I got to get through the dry, boring law stuff first that some people don't like. And they're going to, you know, go to a different podcast or something. So you're like, this is, but you have to know this stuff. You have to know it if you're to truly understand what's going on right now, what the elite are trying to set up. They're touting AI and this whole digital system, digital revolution, if you will, as freedom from poverty, freedom from hunger, freedom from toil, because the machines can just do the work for you, right? That's not true, maybe for them, but what the real freedom that they're talking about is freedom from God. You know, the Statue of Liberty, a lot of people probably already know this, is actually based on a 17th century painting of Lucifer. I think it was the 17th century, holding up a torch. It looks identical, right? So yes, the Statue of Liberty is probably actually an androgynous fallen angel. But if you look at the Statue of Liberty's foot, there is a broken chain. So they erected this thing here just off the coast of the United States under the guise of representing the liberty that America embodies, right? The United States of America, even though that was very short-lived. Pretty much when they ratified the Constitution, they started putting the chains back on, but that's not what that actually symbolizes. That broken chain symbolizes freedom from God's law. Some people say, oh, it's the chain, the angel released from the abyss, right? Apollyon, all that good stuff. From my knowledge of the law, and hopefully by the time I'm done explaining this to you, you will actually see where I'm coming from. I personally think that it means freedom from God's law, because they know that they cannot create law and they are subject to God's law. In fact, a lot of these guys are absolute degenerates at the top. They are usually buggers, as they say in England, or sodomites, right? Generally, they're ruthless, cutthroat. They'd kill somebody to take $1 out of their pocket, metaphorically, probably not, right? And they're awful people who do not want to be subject to the law that will eventually punish them one day, the law by which they're going to be judged. So they're trying to create an artificial and counterfeit system using the concept of trust, right? That's why it says right on your Federal Reserve notes, "In God we trust." In fact, they've already set up the entire system, and you're already existing in it right now, this artificial trust indenture system. What they're trying to do now is make it permanent. Okay. So we're going to get into this stuff. Let me say hi to those of you in the chat. You have Ryan McVeigh. Good to see you. DY or Dis123. This is a new member. Good to see you. We have, I think I see Living American. Good to see you, man. We got Eddie. Hold the line, G. Good to see you. And I think if you're, we got Grammy9, Scots are sovereign, and Sergeant Frog Dog. Good to see you guys. All right, so if I missed you, I apologize. Well, there's Jerry Son of Mick. Good to see you as well, Jerry. All right, without further ado, I'm going to get into this stuff because there's a lot to cover. It's a complex topic. I'm going to try to make simple. Well, not try. I mean, I am going to make it as simple as it possibly can be made, right? And emphasize how it relates to the system that they're setting up. So this is a video we're going to watch in a minute, but what I want to start with is this is a book called The Heart of Blackstone. I've shown this on here before. I want to show you that man does not make law and how this was common knowledge. This is from the early 1900s, I think like 1905, and it's essentially a treatise upon a treatise, right? It's a treatise on a treatise. This is a summary or what this lawyer thinks is the heart of Blackstone's commentaries, which if you do not know what Blackstone's commentaries are, they're one of the most thorough and well-respected treatise of English law in its entirety ever written. In fact, the colonists prior to the Revolution generally had a copy of this, right? It was an essential and they knew the law because they were fighting admiralty courts, much like we are today. That was pretty much the cause of the revolution. That's why foreign and unwarrantable jurisdiction is in the Declaration of Independence as a charge against the king. You're subjecting us to foreign and unwarrantable jurisdiction. That would be Roman civil law through the admiralty courts. So as you can see here, it says the common law is grounded upon the general customs of the realm and includes the law of nature, the law of God, and the principles and maxims of the law. It is founded upon reason, and it is said to be the perfection and reason acquired by long study, observation, and experience. Notice they're not saying that they create common law. So man didn't create common law, God did. Okay, all the things that are unlawful, in order to commit a crime, a real crime, and break the law, you have to violate somebody's free will. Common law crimes, right, are harms. We didn't write that. Right? We didn't create that. So, theft, right? Trespass de armas, which is like basically like an armed robbery or an armed assault, et cetera, et cetera. All of these things, we didn't create that fundamental law that it's wrong to subject or to violate another's will or to subject them to your will without their consent, period. And when you think about it that way, you're like, oh, okay, wait, maybe we didn't create law. Right? No, what they did was they observed this fundamental law and then they wrote it down. And in fact, common law throughout the first 1,000 years after Christ's death in England was not written. It was unwritten. It was orally transmitted because it was considered an abomination to write the law down. It didn't need to be written, and to write it would give man the opportunity to be deceptive, which is exactly what happened in the Magna Carta. It infected common law with Roman trust law and created the very back door that they use to tell you how to use your property today. Okay, so that's the heart of Blackstone. We're going to pop over to actual Blackstone's commentaries, book 1. And he says, the law of nature being coeval with mankind and dictated by God himself. And if you're an atheist and you found this channel, or you're an atheist and you consider yourself a student of law, you're only going to be at a very surface level of study until you accept the fact that the fount of authority is the almighty creator. That's a fact. And that's why Blackstone here is laying it out like this. He says, the law of nature being coeval with mankind and dictated by God himself is, of course, superior in obligation to any other. It is binding over all the globe, which obviously is a glober, in all countries and at all times. No human laws are of any validity if contrary to this, right? That's where Marbury versus Madison gets the any law repugnant to the Constitution is null and void, because the Constitution Constitution was made at common law and is supposed to, and every government's very first compact or arrangement that basically laid out the framework of the government had to be made at common law, because common law is the original and fundamental jurisdiction, because man did not create it. So it must necessarily be. So what man has to do is create contracts at common law and then use those contracts to pull you out of common law into a realm of private law between consenting, by the consent and free will of two or more parties, period. So it's binding over the whole globe in all countries and all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority mediately or immediately from this original, period. So statutes are not law. Codes are not law, obviously, right? Statutes, codes, rules, regulations, all of those things are man-made. They're not law. And they only take the force of law, also known as the color of law, when there is consent between the government and the governed, right? Or when there is some sort of trust arrangement, contract or trust arrangement, or either through a trust instrument or just by implication through a state of dependency, which we're going to get to in a minute. That's how they get you, is this dependency. If you don't know that, go watch my stream, Dependency Cause, the engineering slavery through dependency, I think is what I call it. Servility, that's what it is. Engineering servility through dependency. I lay it all out there. So it only derives the force of all their authority immediately or immediately from the original. So in order for a statute or code to just automatically take on the color of law and have the force of law, it has to be in accordance with the law. So if it is not, so if I've got my property here and you're staying on it as a tenant, right, or something like that, and I write, do not kill people, right, or say it's my property, my town you're just passing through. Now, all my statutes, if I say my citizens have to wear pink shirts on Fridays, and these people have agreed to live under my rule, right, then all of the citizens have to wear pink shirts on Fridays, However, if you're just passing through the town and it has to be Friday and you're not wearing a pink shirt, well, I can't enforce that under the color of law on you because you've never agreed to be under my arbitrary rules and regulations, right? And it's not in accordance with an actual law, so I have no police power over you. However, if I have a statute that says do not kill people, right, without just cause, and you come into town and you kill somebody, well, I don't need your consent because that statute automatically takes the color of law because it's in accordance with law. So the only two ways, and I hope I'm clearing up a lot of confusion about what color of law is, the only two ways that something can take on the color of law is if you're in some sort of contractual trust or trust arrangement that causes it to apply to you via your consent and free will, or if it is in accordance with the law. That's it. Only two ways. Okay. So law of nature being coeval with mankind and dictated by God himself is of course superior in obligation to any other. And it tells you right here, Blackstone himself saying that man's rules and regulations essentially can only derive force as if it is immediately or immediately in accordance with the original. So, all right, let's hop over here real quick. So this is why we're subject to common law. Every man. I like to call common law the law of sovereigns. And not just because here in the United States, originally the several United States are sovereign and the people of the United States are sovereign. Okay. And I'll prove that in just a second. Because, so when cops go, well, you think you're a sovereign citizen? Show them Chisholm v. Georgia. I'll show you Chisholm v. Georgia in just a moment. But anyways, the reason I call it the law of sovereigns is because even the kings and the Pope, right? The kings of the world, queens of the world, and the Pope himself are subject to this common law because it's not written by men, it's created by God. And why are they subject? Well, Blackstone lays it out nicely. Man, considered as a creature, must necessarily be subject to the laws of his creator, for he is entirely a dependent being. Now, what he means is you have no choice but to be dependent upon God because you couldn't exist without God. You exist within God, right? And God exists within you. There's just no choice. You don't beat your own heart, right? You don't draw your own breath when you're sleeping. The system was all designed and created and operates according to laws that you did not create, and oftentimes you do not even see. Okay, so what does he mean by dependent being? That's what he means, is you're dependent upon the creator. But he says a being independent of any other, meaning anything other than God, has no rule to pursue but such as he prescribes to himself. Meaning if you're independent, you are only the subject to the laws of the creator, because you have no choice but to be dependent upon the creator. And that's why God's laws, right? The 10 Commandments, all that, that's why they apply to you, whether you want them to or not. And this is what the elite hate. Okay. But you're independent of any other, right? So you have no rule to pursue but such as you prescribe to yourself. Meaning, as long as you do not violate the free will of another person, you're free, and you do not violate the will of God by breaking his laws, then you're free to do whatever you want, right? Okay. Now, this is where it gets tricky. It says, but a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. That is why they engineer dependency, because that by operation of law automatically creates a trust. Okay. It's settlement. As soon as you accept a benefit, right, or you rely on something from an outside entity for the survival of your estate, you by operation of law automatically convey either a portion or the entirety of your estate to that being, the administrative control of it, and you become subject to their will. They now get the controlling interest of all of your property, including your body. This is called administrative law. Now, administrative law is not law, but it's recognized by law because it's considered basically a charitable relationship where, one entity has been charged with caring for an entity who cannot care for itself. So everything that is done in that situation by the administrator must be done for the benefit of those under administration. Well, that's the situation we're in today. And the government is the United States is daddy government, right? It's your guardian, your ward under the United States. You're basically, they actually consider you an infant, Title I, Section 8. We'll get into that a little bit later. All right. So like he says, not indeed. So it says, but a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. Not indeed in every particular, but in all those points wherein his dependence consists. So a pauper, for instance, is entirely dependent. A pauper is, and this is how the church was able to create workhouses, or they didn't create the workhouses, but basically profit off of workhouses and create the concept of settlement certificates and all that stuff, right? Because the church historically had been charged with caring for the poor. So around the 1600s, there was a series of poor laws passed as they were getting everybody out of the woods and villages and into the cities so that they could engineer this dependence and have a bunch of slaves for their workhouses. They passed a bunch of poor laws where a poor person would be issued a settlement certificate that basically gave them the privilege, like that was their equitable right, if you will, which is a privilege, to live in a certain town and work. But everything that pauper did had to be in accordance with the administrator's will, and the church would be administrator, right? The ecclesiastical courts. That's why the word minister is in the word administer, right? And administrative. That's what it is, ministerial. It's ecclesiastical. It's an ecclesiastical office, and it's supposed to be benevolent and philanthropic, if you will, right? So that's the purpose for the creation of all these NGOs and nonprofits, is because this entire system is a trust indenture system, and that's how they are funneling public money into private pockets, is through these various NGOs and nonprofits they create and usually hold some high position in, whether it be board member or president, CEO, et cetera, et cetera. But even the space agency itself is under, look at this, I'll show you. Title 42. Look at this. And we'll get, I know this probably will be confusing if you don't know how this happened. I am going to be explaining that because it ties right into the digital ID and AI governance. Bear with me. But look, The Public Health and Welfare National Space Program. Why is the National Space Program and Public Health and Welfare? Because everything that they do has to be for your benefit. So they had to frame the legislature creating the space program in such a way as it seemed like it was for your welfare and benefit. Look, so every single sentence starts out like this. The Congress declares that the general welfare and security, right? And security is also a benefit. So that's another big thing. That's how the 14th Amendment places you under administration even before the bankruptcy, because you get privileges and immunities protected by the federal corporation as an enfranchisement in exchange for administrative control. So right here, Congress declares that the general welfare, right? Congress, then you get to the next, Congress declares that the general welfare, and it has to always be framed that way for them to be able to appropriate the money justly under the system that they've created. Okay. All right, let's hop back to Blackstone. We'll fast forward to how this happened here shortly, and I know the jurists in the audience are already well aware because we talk about this all the time in the Jurist Society. So, all right. So yeah, we already went through that one, this one. Okay, so because of this, state of dependence will subject you to the will of that whom you're dependent upon. They use this knowledge, this fundamental knowledge, and see how common law, this is common law translated into an applicability in society, but then they inverted it. Okay, so this is common sense. They basically looked at, well, we're all dependent upon God. We have to follow his laws because of our dependence upon him, right? So we could translate this in society and say these poor people who can't take care of themselves must be dependent upon our will, right? And that's why they created a mirror of the original trust between God and man, and that was the birth of trust law. So you guys would be interested to know, in England, this is how, like I said, for the first 1,000 years in England, after Christ's death, the law was unwritten. It was orally transmitted, and it was considered an abomination to write the law because it gave man the opportunity to lie. England was self-governing. Okay, they had what was called 100 courts, and these 100 courts would be an area consisting of approximately 100 families, where the men of those families would get together regularly and settle internal disputes between the 100 families. And they would do that according to the common law. Now, because the common law is also spiritual in nature, there was a spiritual aspect to this as well. And they would handle spiritual issues as well, like offenses against, say, God, right? But none of this law was written down, and it didn't have to be. Okay. And they were self-governing. So William the Conqueror came over 1066, called the Norman Terror, right? Laying the Norman yoke upon England. And when he came over, he conquered England, but he didn't immediately replace its government or its system of law. Instead, what he did was he allowed them to keep their common law, but took their ability to form a defense against invaders. So obviously they neutered them, took their military law, their ability to structure a hierarchy of defense. Now, he left for a little while, and I personally think he staged an invasion by Denmark. All right, but either way, Denmark came and invaded. And they occupied for a period of time, and then for whatever reason left, which is why I think William did it. And Blackstone will back me up here, because I'm going to actually verify all this right out of Blackstone's commentaries, which was written in the 1700s. So he came back and said, hey, being occupied sucked, huh? Pretty much. I mean, not verbatim, obviously, but he's like, how about you adopt this new system of law called, I don't know what he called it back then, but we call it feudalism, which is essentially what communism and fascism both are. Okay, and this was all inspired, let us not forget, by the Holy Roman Empire. That is who William the Conqueror was spreading feudalism across Europe on behalf of. And of course, the church, being the very first embodiment of the trust between, worldwide trust between God and man, had this in mind to use as a way to conquer and basically unify the world under the Pope. So what happened was you'll see right here, he says, for whereas before the possessions of their, okay, actually we'll start up here. Scarce had these northern conquerors established themselves in their new dominions when the wisdom of their constitutions, as well as their personal valor, alarmed all the princes of Europe. So all the princes of Europe seen this feudal system as the most genius form of government, giving man the opportunity to create, or well, you still can't create law, but create rules and regulations regarding the use of property and then enforce them under the color of law because of a trust arrangement. Now, I'm really going to try to make this make sense for everybody. Okay, so he says right here, whereof most of all, so this is, he's talking about right after William the Conqueror conquered England, right? He says, for whereas before William conquered England, the possessions of their subjects were perfectly allodial. Now, if you do not know what allodial means, I want to show you because this is so important. All right, so we go allodial title. And AI will tell you allodial title refers to a form of land ownership that is completely independent of any superior landlord or sovereign authority, meaning you are the highest sovereign authority on that land. There's no property taxes, right? So it says where the landowner is not subject to any rent, tax, or service obligations. So there's no getting a permit to build an addition on your house. There's no property tax. There's none of that stuff, right? So now that you know what allodial is, and all lands here in the United States are allodial, and feudal tenures are prohibited. That's from Wisconsin, 1848 Constitution, Article 1, Section 14. And I will show you guys that in a little bit as well, because I actually have a photocopy of that from, I think it's archive somewhere. Anyways, I've got it. So whereas the possessions of their subjects were perfectly allodial before William the Conqueror, and he says that is wholly independent and held of no superior at all, meaning the king himself could not tell people what to do on their land or with their land. That's how England operated, right? And that's actually biblical, because you'll read in the story about Ahab and Jezebel that he was jealous of the land of one of his subjects, but he couldn't just take the land. So Jezebel wrote a letter, right, that was offensive to the authorities, and used the guy's seal to seal it. And so the authorities thought it was from him. That's what a seal was for. And we use seals all the way up to the 1800s in this country. But they thought it was from him. And so they came and they executed him. And now the king was free to take the land. So he had to engineer the guy's death to take his land. He couldn't just take it. And that's what allodial means. And it's biblical, and that's how it's supposed to be. It's how it's supposed to be. The king of any nation or the leader of any nation is only supposed to facilitate commerce and adjudicate disputes. That's it. Especially like contractual or things that are made by men can be adjudicated by men. That's why contracts and trusts are adjudicated in equity, but I don't want to get ahead of myself. So it says so before it was perfectly allodial, right? Now they parceled out their royal territories or persuaded their subjects to surrender up and retake their own landed property under like feudal obligations of military fealty, right? So what that means is what William the Conqueror did is he said, here, register all of your land in this doomsday book. This is how he was able to start enforcing his rules under the color of law, which is what feudalism is. So all of the property came to him via registration, because registration from the Latin regnatum means to be governed, right? And whatever you register, you give the controlling interest of it to whomever you're registering it with. And so they all registered their land in the Doomsday Book. And therefore, King William became the superior interest in all, held the superior interest in all the land of England. And instead of keeping it for himself, what he did is he gifted it back out in trust under title and said, okay, now you'll be known as a baron. Now you'll be known as this, right? I can't think of any other titles over there off the top of my head right now, which is weird, but you get the idea, right? He started gifting them back out under title. So here, register it with me, and then I'll give it back to you. But now I hold the superior interest in it, so I'm going to gift it back out to you under certain conditions to be held in trust. Now I can make rules regarding the use of that property and enforce it upon you as if it's law. right? So I will say, hey, you are now known as this title, right? You must hold court for disputes of your tenants on your land, right? And I'll imbue you with a portion of my sovereignty to do so. You represent me when you're adjudicating these disputes. And he says you have to pay me rents and profits, right? You have to maintain several nights' fees to be called to my service at any point in time, right? They have to do their shift of castle guard and all. So he was able to make a bunch of rules and collect rents and profits off of all the land that formerly just belonged allodially to the English. And now he's just got, so it created basically like a pyramid scheme. And it is still considered a military style of governance because everyone has an interest in everyone else's property. So you all have mutual incentive to protect each other. Right. And you maintain knights fees and all that at the ready. So we come down here a little bit. He says, but this feudal polity, which is what I just explained to you, which was thus by degrees established over all the continent of Europe, but seems to have been received in this part of our island, at least not universally, and as part of the national constitution till the reign of William the Norman. So he says later down in here, let me see if I'll find it. He says basically across all Europe, this thing was being implemented simultaneously, but it was being done in degrees across the rest of Europe. But in England, here, I'll just read it. He says this new polity, talking about the feudal system, therefore seems to have not been imposed by the conqueror, which is true. But that's why I think he used the Hegelian dialectic with the invasion of Denmark. And trust me, all this stuff is so important for understanding what's going on today because they use the same system. This is when this system started to be built. That's how long of an agenda this has been. This is all part of the same agenda, what I'm reading to you right now. We are at the end of this beginning of the story. So this is the beginning of the story. We're now in the end of it. Took about 1,000 years. Okay. So the new polity, therefore, seems to have not been imposed by the conqueror, but nationally and freely adopted by the General Assembly of the whole realm, in the same manner as other nations of Europe had therefore adopted it, upon the same principle of self-security. And in particular, they had the recent example of the French nation, which is Norman, right, before their eyes, which had gradually surrendered up all its allodial or free lands into the king's hands, who restored them to the owners as beneficium or feud or trust, right? So he got all the land, they surrendered up all the land, allodial title, and the king gifted it back out under a feud or a trust, right? To be held to them and such of their heirs as they previously nominated to the king. And thus by degrees, all the allodial estates in France were converted into feuds, and the freemen became vassals of the crown. If this was on a map, there would be an arrow pointing down saying, you're here at the last part of that sentence. Vassals of the crown. 14th Amendment citizens are British subjects, okay? Period. So, and really, I would say they're actually Roman subjects in all reality, right? So this is so important because the whole cause of the Revolutionary War was this system that had been built up to a point of near absolute tyranny and was being imposed on not only the English, but the colonists as well, all around the world, not just here in America, and imposed upon the colonists. And that's why, and I explain this all the time. So here's the next part of this thing, right? So in the same way that we do not create law, when we won our independence in 1776, we didn't go, okay, what do you guys think the law should be? What do you think the law should be? Yeah, I think we shouldn't do this, and that. No, we kept using the same common law. But what shifted, and I'll show you this right now, actually. You'll be surprised to know. Chisholm v. Georgia. Yeah, we'll go here we're going to have to pull up the Justia one because case text actually closed down. So you go to this, Chisholm v. Georgia, 419, 1793, right? 2 U.S. 419, 1793. And you do Control F, okay? And you go at the Revolution, right? So at the Revolution. And now you'll have two results. You want the second one. And there we go. So at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of this country, but they are sovereigns without subjects. So we didn't create new law. We continued using the same common law, but we became the sovereignty. We became the crown. I'm going to continue reading this. So now that's why you have a lodial title in this country. And like I said, I'll show you Wisconsin Constitution as well, because who could possibly be above you? No one. Who could have a superior claim to your land if you're now the sovereignty? No one. That's why that's in the Wisconsin Constitution, right? So it says, at the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slaves among us may be so called. And now, interesting about that, that's only because they were in a position of servitude, not because they're African. Even Andrew Johnson himself said, after the 13th Amendment that abolished the second 13th Amendment, the one that abolished slavery before the 14th one standardized it, he said the 14th Amendment and the Civil Rights Act were unnecessary. He said this in a veto message about the Civil Rights Act. He said, because, first of all, it takes the power of conferring citizenship away from the states and gives it to Congress. And secondly, because though they're in a state of dependence now, and remember how dependency causes you to come under administration, he says, though they're in a state of dependence now, in time, they can learn to be free. So all it would have took was for them to develop trades and get the idea, learn the law and start operating within the common law system. And they could have had all their common law rights to property and everything. That's a fact. So it says that they're sovereigns of this country and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. And since I just explained to you feudalism, now, this case actually distinguishes us, even though we're neo-feudal now, from feudalism. It says, from the differences existing between feudal sovereignties and governments founded on compacts, which is what we have, it necessarily follows that their respective prerogatives must differ. Sovereignty is the right to govern a nation, or state sovereign. It says a nation or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty is generally ascribed to the prince. Here, it rests with the people. There, the sovereign actually there's that word administers the government. Here, never in a single instance. We are not supposed to be under administrative law. Our governors are agents of the people and at most stand in the same relation to their sovereign in which the regents in Europe stand to their sovereigns. Think about that for a second. This case just told you that the government are your trustees, that the government are your servants. They're beneath you. They're not leaders. There's not leaders and lawmakers in Washington, okay, or in your state capital. It's nothing like that. First of all, they're not leaders. They're servants. And second of all, there's no such thing as a lawmaker outside of God. But because they've placed you in this 14th Amendment citizenship trust, right, now they're your administrator. One more quarter. Grom, I see we have quite a few people popped in. Good to see you guys. Sorry, I gotta cram all this information. So if I'm not saying hi to you as you come in, please forgive me. All right, so that's Chisholm v. Georgia, 1793. Very good case to have, guys. Very good case to have. We want to go back to, well, hold on. Let's see if I can find that Wisconsin Constitution real quick. Here, let me stop the sharing for a second, just so I can show you guys and further impress that point. Let me pull this up. This is going to be right here. Okay. And we will get into this too, the 14th Amendment, all persons, whereas the Constitution begins with we the people. This begins with all persons, which is not the people, right? These are entity, persona. Person comes from the Latin persona, which is a mask. Okay, in the United States, it's a legal fiction, and it delineates that you're subject to the jurisdiction thereof. So this creates British subjects. All right, but anyways, the allodial title. I got a ton of, there it is. All right, bam, Wisconsin Constitution. We'll go to the top so you can see. State of Wisconsin in the adopted first day of February in the year of our Lord, 1848. Okay, legitimate Constitution. Section 14 of Article 1 says, and let's see if we can zoom in even a little bit more. All lands within this state are declared to be allodial, and feudal tenures are prohibited, period. So you are supposed to have allodial. There's not supposed to be property taxes. There's no such thing as getting a permit to do something on your property. There's no such thing as statutes and ordinances affecting your property under our original republic. It was brilliant. The way this was established was absolutely brilliant. All right. So now I got to go back to, and as a side note, if I have it pulled up, the United States is and always has been an English company, right? So first you can go here to the Treaty of Paris. Yeah, we don't care. And you can read how, and also all the kings of Europe have been under the Holy Roman Empire, because the Pope was the one declared that to have the authority to confer the divine right to rule, essentially, right? So as the vicar of Christ, but it having pleased the divine providence to dispose the hearts of the most serene and most potent Prince George III. So he's called Prince George, right? By the grace of God, King of Great Britain, France, and Ireland, Defender of the Faith, Duke of Brunswick and Lunenburg. And now this is where it gets interesting. Arch-treasurer and prince-elector of the Holy Roman Empire, etc., and of the United States of America. Bam. Okay? The United States is a foreign corporation. It is not part of any of the states. It is absolutely foreign to it. And let me show you this. Let's see if we do the Company's House, if I can pull that up real quick. Let's see. United States. Well, anyways, it's on the Company's House. I do have it pulled up somewhere. United States. There, I thought I just seen it. States Company's House. There it is. All right, cool. Got it. Boom. Instead of having to dig for it, I just wanted to get to the link. So look, United States of America on gov.uk. One active beneficial owner. Doesn't sound like the people. 33, of course, 9 Elms Lane, London, United Kingdom's correspondence address, right? U.S. Department of State oversees buildings operations, right? So look at this, notified on the 3rd of July, 1776, and it issues a statement every year, right? On the owners and as it says, it says all beneficial owners have been identified and all required information can be provided, because it's right here. Nobody has become or ceased to be a beneficial owner during the update period, right? So that means the original single beneficial owner is still the beneficial owner. So you have to understand who you are when you're a U.S. citizen instead of a Michiganian or a Ohioan or a New Yorker, because those are your actual countries, okay? In fact, this was common knowledge, again, up until Rockefeller took over the education system. Look at this. So you have, these are boundary stones, caging in the Leviathan of the United States, okay? Caging it in, boom, boom, boom. On this side of the boundary stone, it says jurisdiction of the United States. Out here, it says Maryland when you're going back into Maryland. This because the jurisdiction of the United States is entirely separate from the jurisdiction of the several states. And the jurisdiction of the several states doesn't need any more explanation because it's common law. Whereas the United States operated in admiralty primarily because its purpose was to engage in overseas business and diplomacy. So I hope you guys understand this. Now let me get back to the law aspect of it, so I don't want to stray too far from my original point. Now, since man cannot create law, man came up with this clever idea, specifically the church, to lock entire nations into trusts. Now, because the people of the several states were sovereign, as we read in Chisholm v. Georgia, and could not be subjected to the United States corporation because it is foreign to them, and Congress cannot, with them, Congress does not presume to deal, as it says. So there's actually a case, Long v. Rasmussen, right here, Long v. Rasmussen. And basically what happened was a state citizen was distrained of property for an income tax shortly after the establishment of the Federal Reserve, 1913. And then they started trying to implement corporate tax acts against the federal enfranchisements, right? So they tried to distrain the state citizen of her property, and she sued the IRS agent himself, because that's what you have to do when you sue somebody according to law or the equity that accompanies common law, not the Roman civil law equity that we're under today. And I'm going to get into the distinction between those if you're new to this. But it says the collector assumed in good faith to distrain the property he believes to be the taxpayers. Right, says the non-taxpayer owner, however, is free to bring any other proper action in the court to determine the title, ownership, and possession. So the reason I'm bringing this up is because there is one part here, right here. The revenue laws are a code or system of regulation and tax, or in regulation of tax assessment. And I want you guys to understand that this is written by a bar pirate. So he's not going to say state citizen, federal citizen. But I'll prove that to you guys in just a moment as well. What he says is taxpayer and non-taxpayer, which is the same thing, because the only ones who are subject to that feudal tax are the 14th Amendment feudal subjects. So the revenue laws are a code of or system and regulation of tax assessment and collection. They relate to taxpayers and not to non-taxpayers. Okay, the latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in the due course of law, because they cannot. With Congress, or with them, Congress does not assume to deal, and they are neither of the subject nor object of the revenue laws. And that's because Congress only has jurisdictional authority over the federal citizen. Okay, so now let me do something real quick. I wonder if it wouldn't just be easier to switch over to the other one. Probably would be. Okay, hold on. We're going to do that. I got two different pages with a bunch of stuff on it, so bear with me. It's just so I can see the tabs, you know? All right. So we have, if you're new to this channel, McDonald v. State. That shows you the distinction between the two citizens. It says this guy got convicted by a jury in Indiana, and he appealed the case and tried to get it overturned because he said one of the juries was an alien. See, ninth, he is an alien, right? So they rejected his appeal because they said the evidence of bushing, which was the German, so this guy moved from Germany, naturalized in Indiana, but didn't become a 14th Amendment citizen. He just naturalized within the state. It says the evidence of bushing on his voir dire, which is to see if a juror is competent to be a juror, showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. Period. Okay, we'll go over here. Maxwell v. Dow. This is why when you go into the court and you try to talk about your constitutional rights, they don't want to hear it, because no part of the Constitution applies to you except for the 14th Amendment. Shows you right here. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Yeah, 14th Amendment citizens are not entitled to the Bill of Rights at all. Okay? At all. We have this one, United States v. Anthony. Says the 14th Amendment defines and declares who shall be citizens of the United States and protects only such rights as are rights belonging to persons as citizens of the United States and not rights belonging to persons as citizens of a state. That's it. It's an entirely separate form of citizenship. You've even got Black's Law Dictionary, 4th edition, will tell you that the 14th Amendment became part of the Organic Law July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizenship of the United States as distinct from that of the states. So even Black's Law Dictionary, 4th edition, is telling you it created a separate class of citizens who are not people, they're persons. And the very nature of the 14th Amendment itself, right, is a trust. So let's see. I know I pulled up the 14th Amendment here and we were looking at it. Now I gotta, there it is. 14th Amendment. So all persons, whereas the Constitution begins, we the people, it says all persons born or naturalized in the United States, subject to the jurisdiction. See, subject, that word is huge, because remember what Chisholm v. Georgia said, the people are not subjects of the government. The government officials are subjects of the people, because they stand in the same relation to us as a subject would to the crown in Europe. That's Chisholm v. Georgia, not me. So anybody wants to say, oh, that's crazy conspiracy theory, you're not sovereign, blah, blah. Yeah, you are. Actually, the 14th Amendment citizen is not. So it says no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. So you have to look at who this was made for. They're persons. It's automatically a trust position. And what you were, so if you were a newly freed slave, it would give you privileges and immunities because you were not able to exercise common law rights in a state of dependency, right? So this was made for that specific reason. But then as other people started to become 14th Amendment citizens, and of course, all the states began mass importing immigrants who would immediately naturalize as a 14th Amendment citizen, right? But as these people started to become 14th Amendment citizens, you're literally trading your unalienable God-given rights, your sovereignty, your absolute right to property, in exchange for privileges, immunities, benefits, and protection of those things. See, a free man or woman protects those things, him or herself, right? That's it. But when you agree, say, hey, okay, I'll come under you, daddy government. I'll be a ward, daddy government. Just protect me and give me all sorts of benefits and privileges and immunities. Well, what you don't realize is going to jail is a privilege. That's why they call it corrections. And they give you privileges or they give you benefits. Absolutely. So now, why did they do this? 2 reasons. One, because the federal corporation had the authority to create and control currency, right? And they never had the authority to delegate that to anybody, but they did anyways to the private central bank. And they knew that's what they intended to do. So the federal government needed its own collateral. See, it had no jurisdiction over the people in the state, so it couldn't collateralize them, right? And damnify them, as it's literally actually called damnification. So what they did was they created their own citizenry, their own subjects. And you'll know this is the reason once you read the fourth section here. The validity of the public debt of the United States, right, shall not be questioned. Well, what the hell does that have to do with equal protection? What does that have to do with granting civil rights to disenfranchised people? Not a damn thing, unless you know what the actual plan was. The actual plan was to have their own pool of collateral, agricultural collateral, to mortgage in exchange for loans from a private central banking cartel. And that's exactly what they did. That is exactly what they did right here. March 9th, 1933, page 83, House Congressional Record, second paragraph from the top here. It says, and don't look at the right column because it's going to highlight there. This is straight off of congress.gov. It says GPO on the file name. It says the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. They mortgaged your property rights, guys. So that allodial title and that absolute ownership, no one taxing you or telling you what to do with it, that's gone immediately. It was already gone when you became a 14th Amendment citizen, but they at least faked it for a little while. Once they mortgaged your right to property, oh no, that's all subject to the bank now and to the administrative quasi-governmental corporate bodies that they established to create regulations. And they admit to it here in this law review. Okay, they admit to it right here. They say This is from UCLA Law Review, Fiduciary Foundations of Administrative Law, it's called. And it says the emerging fiduciary model, right? And a fiduciary is a trustee that makes financial decisions on behalf of another, which is what they're doing when they're managing your credit and telling you how to use your property. It says, so the emerging fiduciary model in administrative law posits that administrative agencies, right? So what are administrative agencies? The EPA, the DMV, the IRS, the ATF, all these agencies that can make rules and regulations affecting your property, and specifically the property that's been registered. The ATF, the registered firearm, the DMV, the registered automobile, right? Particular things that have been registered, because remember what register means. It comes from the Latin regnatum, to be governed. When you register something, you give the controlling interest of it over to whomever you're registering it with. So that administrative agencies are endowed with authority to set regulatory policy. Well, what's regulatory policy? What is regulatory policy? Well, let's take the ATF, for instance. That's telling you what you can and cannot put on your weapon, what weapons you can own, the conditions, right, under which you can own them, et cetera, et cetera. Let's look at the DMV. What regulatory policy do they set? Well, how to drive, how to operate. No, both those words are commercial. How to travel in your automobile. But really, they disguise it as commercial. And that there's a very specific reason for that. We may not even get to every facet of this today, but I'm going to try to get you as much as I can. So to set regulatory policy, now this is where it's important. When Congress and the president acted jointly as proxy settlers for the sovereign people. What is a proxy settler? Well, proxy is on behalf of someone else, right? And what is settlement? Well, let's take a look, shall we? Settlement, the conveyance of an estate for the benefit of some person or persons. That, what he just said, this, acting jointly as proxy settlers for the sovereign people, was a very churched up lawyery way to say this: mortgaged you, mortgaged your rights to property without question. Okay, gone. So now there's regulatory agencies telling you how to use your property. It goes back to the same concept of when William the Conqueror took over controlling interest of all the land in England via registration, then gifted it back on under title. Now he could administer the land, administer the government of that property, because he had the superior interest in it. That's how they get superior interest in all your property, and that's how they can enforce their arbitrary rules and regulations against you under the color of law. But the caveat to that, they cannot use law, okay? They cannot use courts of law to apply this. And I'll show you. So first, we're going to start to understand what I mean by that. We've got to start with Article 3, Section 2, right, the Constitution. It says the judicial power shall extend to all cases in law and equity. It distinguishes law from equity as two separate bodies of jurisdiction. So equity is not law. But if you look at, like, say, Federal Rules of Civil Procedure, Rule 2, it says that we're now all under the civil action, which is equity, right? Or Roman civil law. So if equity is not law, but that's what they're using against you, how and why? Well, because equity got its start when trusts came into popular use, and it was called chancery specifically. And it was a way they had to, because they couldn't use courts of law to enforce all of the arbitrary regulations on the property. So they had to have some other way to compel trustees to follow the rules that were set according to the trust instrument and trust arrangement regarding the use of property. So if the trustee was not using the property properly, that's what chancery is, what it was originally called. It's now equity. Chancery was for. I'll even show you. We've got this practical treatise on the law of trusts from the 1800s, right? And this guy will tell you. It says originally, well, first I'll tell you, right, the origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. By the interposition of a trustee, the debtor thought to withdraw his property out of the reach of his creditor, the freeholder to intercept the fruits of tenure from the lord. of whom the lands were held, and the body ecclesiastic to evade restrictions directed against the growing wealth of the church by the statutes of mortmain. What they neglect to mention is that for the rulers, it gave them the ability to create arbitrary rules and regulations and enforce them on everybody as if it's law. That's the biggest thing. And against their property. To be able to, this created a system of usury of property. But back to equity, what I was talking about there. It says originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee. But the mere feeling of honor, proving as was likely when opposed to self-interest, and extremely precarious security, meaning, people's words don't mean shit when they stand to profit off screwing you over. So he's saying to make sure that trustees use the property the way that the owner, or they call beneficial proprietor, tells them to through the trust instrument. It says John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena, which is now called summons. Subpoena was only when you still had some access to law and you were considered somewhat alive to the law, but now you're entirely dead to the law after the United States became insolvent in the 70s, and they finished setting up their entire commercial equity system, their trust indenture system. There's even an enactment called the Trust Indenture Act of 1939 that lays out, it's basically the groundwork or the framework, the foundation of all of the regulatory policies, such as the Motor Vehicle Code. So, something interesting. But anyways, it says the writ of subpoena by which the trustee was liable to be summoned, there you go, into chancery and compellable to answer upon the oath and allegations of his septicate trust. Okay. So that's what the subpoena, aka summons, and that's what chancery, aka equity, is primarily for. Was these artificial counterfeit systems of governance and quote unquote administrative law that were being set up to usurp the jurisdiction of original law. And if you think I'm kidding, Blackstone talks about how the common law almost entirely fell into disuse. Now they can never get rid of it because it's the original jurisdiction, but it almost fell entirely into disuse in England if it were not for the Magna Carta. Okay. Magna Carta is what I call a double-edged sword. All right. The Magna Carta lays out under what circumstances and conditions someone's property becomes administered. And I'll explain those to you briefly. You are either not of age. So say, your mother and father are both no longer with us, and there's no other family member who's of age to take control of the estate as an executor till you come of age. Then the court automatically gets the privilege of administration. And now the court tells you how to use your property and et cetera, right, until you come of age. That's one way. The other way is being an incompetent, which means either mentally incapacitated, non compos mentis, a drunkard, a spendthrift, some sort of derangement, lunacy, those type of things. The court gets the privilege of administration, or they can issue letters of administration to whomever they so please. Now, part of this administrative law laid out in the Magna Carta is they get to take an administrative fee, but it also tells them that they have to maintain the property of the estate until the heir either returns or comes of age, right? So that's what the Set Decay V Act, without Magna Carta, there could be no Set Decay V Acts, right? Because that's what infects common law with trust law and allows them to take under certain conditions, someone under administration. Now, the third primary way you can come under administration is pauperism, being poor. And the idea is that if you cannot subsist upon your own estate, then you must not have the capacity to exercise your free will properly, and you become dependent. So if you cannot survive on your own, you become dependent upon an entity for survival, just like the original trust between God and man. You must necessarily subject yourself to the will of that entity that's helping you survive. And that's pauperism. Now, think about that. We have no access to lawful money. This right here, they already had administrative control via the 14th Amendment, but now they were able to mortgage everyone's estates under the guise of it being for the benefit of those under administration. Right? So That's also why they have to, every time they borrow money against your estate, it has to be for your benefit. That's why the space program is under health and welfare, like I was saying. So pretty wild. But now, so equity, which formerly chancery, in a court of equity, that's how I want to put this. So in a court of law, it requires a jury, especially here in the United States where there are no kings and the people are sovereign. And why? You have to look at it this way, because you are enforcing God's law, the unwritten law, right? The law that's written on that everyone knows innately. You are enforcing that law, and no one single man or woman has the right to adjudicate a living soul. So what do? Jury. And the jury, because there's a maxim of law that says the voice of the people is the voice of God, right? The voice of the people is the voice of God. So they take a requisite number of individuals, and if they're all in accordance and they concur with one another that you did, in fact, commit this crime and harm somebody, then they find you guilty. No single one adjudicating, but all of them together. And they have to be in absolute agreement, right? So it's really the closest thing to the perfect form of law that we can get in society as a reflection of God's law. And they convict you, right? Now, in a court of equity, no such thing is required, because equity is only for adjudicating primarily fictions, right? And these are creatures of mankind, or creatures of government, basically, right? Made by man. Then man can adjudicate it. And so the conscience of the judge becomes supreme, and there's no requirement for a jury. It's only in a court of equity could you have a bench trial. That's it. Only in a court of equity could you have all three parties in the courtroom that are against you all working for the same entity, the state. That's only in equity, because they're adjudicating contracts and trust arrangements. They're not supposed to be adjudicating living souls. So what do they figure out how to do? How to reduce you to property. So let's look at some evidence of why that's what equity is. Okay, so we're going to go to, I know we got Bouvier's Law Dictionary open somewhere to this. So we'll go to, all right, it's not there. Let me open up a new page real quick. Thought it was already prepared. Forgive me for that, guys. But all right, so boom. And it's under D. Also, while we're here, I can show you guys this real quick, because it's also under D. This is Bouvier's Law Dictionary from 1856. The reason I use this a lot is because it's specifically adapted to the laws in the Constitution of the United States. Okay, so we've got this word right here, damnification, like literally damned. And you'll notice there's a spiritual aspect to indebtedness and to being on the wrong side of a trust, right? As in, let's put it this way, that over in England, and this is in Black's Law Dictionary, the place underneath the exchequer, which is a black and white mosaic pavement tiled floor, right? The place beneath that is called hell. And that is the place where the king's debtors were held. Okay, underneath the exchequer. So there's a very huge spiritual aspect to all this. I can't overly emphasize enough. But it's damnification, that which causes loss or damage to a society. That which causes loss or damage to a society, or to one who has indemnified another. For example, when a society has entered into an obligation to pay the debt of the principal has become bound in a bond to indemnify the surety. The latter has suffered damnification the moment he becomes liable to be sued for the debt of the principal. So the entire nation has been damnified. We have all been subjected to damnification at the hands of Congress and the president. FDR, syphilitic, crippled, piece of shit commie that he was one of the worst things to ever happen in this country. But that was a little bit of a digression here. We're going to go down to what's called discretion. And this relates directly to equity and why equity is actually is a realm of tyrants. In fact, in that treatise of the law of trust, it says that the parents of the trust were fear and fraud, and the court of conscience was its nurse. And what that means is a court of equity. Because in equity, all final decisions are left to the conscience of the judge. Okay. And that's a very dangerous place to be, because these guys are generally highly unstable people, highly egotistical, and usually satanic in most cases, right? You don't want anything to be left up to them. So discretion in practice, this means that law or inequity, right? When it is said that something is left to the discretion of a judge, it signifies that he ought to decide according to the rules of equity and the nature of circumstances. So the rules of equity, right? So he's supposed to be a wise man, the judge is, in a court of equity, and he's supposed to apply his interpretation of what God would find just and unjust. And it's supposed to be generally harmless, because he's not supposed to be doing this with living people. Okay, it's just enforcing, say, if somebody of their own free will entered into a contract or trust arrangement and they're not holding up their end of the deal. I mean, it is still adjudicating living souls, but they end up in this situation of their own free will. And it's sort of an entire body of law that was created, or not law, a entire body of jurisdiction that was created to make sure people keep their word, primarily. Okay. But what if you were tricked? Well, you have to challenge the validity of it. You challenge the covenant that runs with the land at law. Okay. So this right here, the discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. It is casual and depends upon the constitution, temper, and passion. In the best, it is oftentimes capriciousness. In the worst, it is every vice, folly, and passion to which human nature is liable. That's the danger of equity. And Blackstone well knew this. He knew this very well. He, let's see if we can, do I have Blackstone pulled up here on this page? Okay, so we're going to pop back over to the other page real quick for Blackstone. And I hope you guys are getting what I'm picking up when I'm laying down here, because it's so important. This digital ID will permanently lock you into equity, will permanently lock you into the trust indenture forever. That straw man, this is what I'm describing to you. The straw man is a trustee. It's a role. It's a persona. So it's a legal fiction. When they say, oh, there's no such thing as, there absolutely is. There's you, right, under the purview of a trust as a trustee. And that's not you, in fact, at law. And you can never enforce any of those things. Well, I'll get to that. I don't want to get ahead of myself here. Let me pull this up. So Blackstone says, right here, I believe. So he says, on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law and leave the decision of every question entirely in the breast of a judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator and introduce the most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. So Blackstone himself said that we don't want to let this equity thing get out of hand and overtake law, that's exactly what they wanted to do, because that allows them to become, that allows the Bar Association to become God. Okay. That's what this is all about. It's about replacing God and taking God's authority to make and enforce law and giving it to man, because they're usually a bunch of degenerates, and they would rather make the law so they can indulge in their degeneracy and also control everyone else and enslave them, right? So let me see this real quick. So we've got that. There was this, let's see, every judge a legislator. That's what I was going to show you guys. So there's this law review right here. Hold on. I know I got it somewhere here. Buck Act. I got so many different tabs open. Sorry, guys. Where the hell is it? There's a law review that tells you that in the 30s, they abolished the distinction between law and equity. And the reason they did that is because they now had everybody locked in the 14th Amendment trust indenture and mortgaged. So What is equity? I can't find. I'm not going to waste much time. I've got it though, and I've shown it before. It's called a turbulent path to. It says what is it? Admiralty, a turbulent path to manifest destiny, and it basically says in the 60s and 70s they abolished the distinction between admiralty and civil law, just like in the 30s they abolished the distinction between law and equity. Now, you have a lawful right to something if you actually own it. If you have an ownership interest in it at law, like you have absolute ownership interest in it at law, you have access to common law. That's where you enforce that interest, right? If somebody does something with the property, then you can claim an injury at law, all right, and sue for damages. Or ultimately, a grand jury can sue for a punishment worse than damages, depending on the nature of the crime. But if you only have the right to use a thing, right, say as in a trust, because that's what you are now, you're a mere usufruct of even your own body, locked in equity, okay? You only have an equitable right to the thing that you only have the right to use. And that's all determined by a contract. So God gives lawful ownership rights. Man creates equitable contract rights that are usually, terms of a trust. And so, for instance, and I use this example all the time, if I let someone use let's say his name's John, I'm going to let John use my car, okay, perpetually. I'm going to give him the right to use my car, but I maintain the superior ownership interest, and I draw up his interest in a contract, right? Well, a trust is created. The car is placed in trust. He becomes the trustee. And all of the terms and conditions of that trust become either his equitable rights, right, or my equitable rights in that trust. Now, if I say you can't take the car, you have to have the car back in the driveway by 7 p.m. at night, and you can't leave again till 6, and I determine what passengers he can have, and I determine the rents and profits he has to give me for the car, right, for the use of the car, and all the conditions under which he has to use it. Say, I'm just like the DMV, be like, you have to apply to me for a license, right? You have to, it's already registered, basically. It's already in trust. So, and all that, you can't drive it this fast. Now, if I want to enforce any of those things, those rules that I made up as stipulations of the trust, none of those things are law, okay? Because of his free will and consent to be part of that trust, they take on the color of law for him. So to him, they are law, but in fact, they are not law. And so I can't use a court of law to enforce those things, right? That's what equity's for. So I'd have to take him. So say I tell him he has to have the car back by 7 every night and he's out till 9. Well, I'm going to take him to a court of equity and charge him. And I'm going to compel him to answer for his misuse of the property via a summons or a subpoena, right? And I'm going to compel him to answer for his misuse of the property, and then I'm going to fine him according to the terms of our trust arrangement. Well, that's exactly what's going on. And none of it's law. And the only way to challenge the validity of the original indenture is at law. And the way you do that is the 14th Amendment. You challenge the validity of the 14th Amendment as invalid. It was never lawfully ratified, and it's entirely voluntary. And only 14th Amendment citizens are subject to the administrative regulations, such as motor vehicle code, right? So that's the nature of the trust that they have you in, right? And now they're trying to make it permanent. You have no access to law because as a 14th Amendment trustee, you only have an equitable interest in even your own body. And because you're under administration, they have to keep the property, right, until the heir or someone claims it, which is what we teach in the Juris Society. They have to preserve it. So that's how they can tell you to wear your seatbelt in the car. That's how they can tell you not to smoke weed or whatever the case may be, right? That's how they can control what you can and cannot do with your own body. It's absolute control because they got clever and they figured out how to put entire nations in trust. And this has been a long drawn out plan, and feudalism is the key. So a brief synopsis, a brief outline of what's been taking place is essentially, feudalism was established, which if you're just joining us, go back to the beginning of the video because I spent a great deal of time explaining that. Feudalism was established by taking administrative control of all property and then being able to enforce regulations under the color of law because the governing authority has the superior ownership interest, right? Or administrative control of the state, of the property. So feudalism was created. Then a series of papal bulls, right, created the world trust as the crown, as the pinnacle, right, of the trust system that was being spread across Europe. You'll notice it happened in tandem. First, William the Conqueror and his successors went and spread feudalism across Europe. Okay. And then in 1302, Pope Boniface VIII issues the papal bull Unum Sanctum, which is the one world trust, and he declares that it's necessary for the salvation of all human creatures to be subject to the Roman pontiff, right? And then he does Attorney Regis and creates a landlord, right? One prince above all the other princes who's essentially the landlord under him, right? The administrator of the trust. And then he issues the doctrine Dum Diversus, which is the doctrine of discovery, right? The papal bull is the doctrine of discovery, where he says, go out and conquer the heathen lands and take all their shit and bring it back to me, right? And well, you can keep it and give me some and everybody, you know, because we're going to spread Christianity, okay? And trust me, I'm a Christian, so I'm not dogging Christianity, but I'm just saying this is how it's been inverted. So they go and forgive me for swearing. I do that sometimes. I get passionate. But anyways, so all the monarchs of Europe now start going out and colonizing foreign lands, having been given divine authority by the Pope. Well, at the same time, this is roughly about, 1600 at this point, the first company is made, and it's the East India Trading Company, right? Well, I don't know if it's the first, but it's the first major commercial entity, and it comes out of London. And what people don't realize, they all think it's the English that colonized, but they don't realize that from time immemorial, ever since the first century after Christ, London was established, Londinium, and controlled by Rome. Okay, so even in the Magna Carta, it says that London gets to maintain all of its sovereignty and its ancient rights and liberties and all that stuff. That's why you have that little sovereign financial district in London that most everybody knows about at this point. It's actually controlled by Rome, same as the Vatican, same as DC. Okay. Well, all these commercial entities started coming out of London, such as the East India Trading Company. And at the same time, right, they were going out and bringing all these goods back, these resources they were pillaging from the lands they were colonizing. They needed people to work for the businesses, the empires that they were building. So they passed a series of poor laws, kicking everyone out of the woods and out of the villages and stuff by making it illegal to hunt and to fish and to just generally live on your own in the wilderness, right? Or even have access to riparian water rights and stuff like that in a village. So out of necessity, people not only moved into the cities, right, but they also moved into the cities as paupers. And that's when they created the workhouses. And the workhouses were taking those raw materials that were being pillaged from the colonized areas and manufacturing, processing them, whatever the case may be, making clothes with them, whatever. They were able to, now they had a big pool of pauper workers, and the church managed this on behalf of England, right? And so the church is managing it. And what they do is they issue a settlement certificate, which is pretty much what your birth certificate is. It's multifaceted. It serves as a bill of lading, serves as a warehouse receipt. It also serves as a settlement certificate, right? And that's why it's on bond paper. You're in bondage. But anyways, so they issue settlement certificates that tells the pauper where he or she has the right to live, which is really just an equitable right now. Because remember, as a pauper, their entire estate is conveyed to the church in trust, right? And now the church is managing it via administration, hence the word minister. It's always been ecclesiastical. It's a spiritual thing, right? It's because you're considered not to have free will. So anyways, and they're able to, according to the Magna Carta, take a fee for the administration of the estate. And they also tell the pauper how to live, what to do, even with his or her body. All right. Then shortly thereafter, you have the colonists start being subjected to tyranny from the very companies that colonized the area. So the East India Trading Company, right, and the various other companies along with it as the colonies were developed are the essentially de facto corporate government over there. And they start subjecting the colonists to admiralty, right, inland piracy, because now they're basically, because it's a colony and the whole purpose of it is to take the resources from there and ship it back to the home country. They brought the law of the sea inland. And then the final straw was when they wouldn't let the colonists control their own currency. The Bank of England pressured Parliament to make it so that the colonists. Okay, so let me tell that whole story. What happened was the colonists ran out of the material to mint the English currency here in the colonies. So instead of going into a depression, Benjamin Franklin's like, hey, why don't we just print our own colonial script? It won't have any usury attached to it. There'll be no interest on it. And we can, print it in just the right proportion to stimulate the economy, et cetera, et cetera. And so they started doing that. And the colonies just flourished, right? So much so that the Bank of England took note and sent a delegate over here to talk to Benjamin Franklin, who was a piece of shit and part of this whole thing the entire time. That's why they found a bunch of bodies under his house over in France and stuff. But anyways, satanic for sure, member of the Hellfire Club. But anyways, they asked Benjamin Franklin, hey, you guys are really flourishing over here. How'd you do that? He said, oh, it's easy. We just started making our own script, right? And there's no interest on it. And we can keep it, we can make sure it's not overly inflated, et cetera, et cetera. And so what happened was the Crown or the Bank of England pressured Parliament to pass the Currency Act, which forced the colonists to not only use the British currency and nothing else, but also to pay all of their back taxes in gold. And so all those people, all those business owners and stuff, proprietors who had all this colonial script, it just became worthless overnight. And now they were expected to pay taxes to the crown or end up in a debtor's prison in gold that they didn't. Now they can't even convert the currency that they have. They just went from prosperous to absolute pauper overnight. And that was the catalyst of the Revolutionary War. According to Benjamin Franklin in his own diary, he said the colonists would have gladly borne any tax on tea or any such item if it were not for England taking away their ability to print and control their own currency. Sound familiar? It should. It should sound familiar. So, hey, we got Tone B. Like I said, guys, I got a lot of information to go through. So if I don't say hi to you, please don't be offended. We got Valley Park, Scott, New York City, Brian Roy, Mojo Shop in the house. Good to see you guys. All right, Droopy Eyes. Good to see you. Okay, back to this stuff. So he said that was the primary cause of the Revolutionary War. The very reason why we set up the government the way it was set up originally under the Articles of Confederation. Then the wealthy people saw the danger to their dominance and prosperity. As James Madison said, if the interests of the many are united, the interests of the few won't be taken into consideration. So they, against the will of the public, while Thomas Jefferson was off on a diplomatic mission, behind closed doors, with armed sentries outside to make sure nobody was eavesdropping, they drafted the Constitution. And nobody knows what was really discussed because the only records of it were thoroughly sanitized. James Madison's diaries released about 60 years later. Nobody knows what was discussed with them, for sure. We know a little bit, but not much, right? And primarily what came out, what was being discussed is, hey, we can't let these commoners have sovereignty like that. So they created the Constitution, then went around and instead of having it ratified by popular vote, they created delegations, conventions, right? They created conventions and had the convention vote. And guess who was part of the convention? Just the wealthy, right? And they got to ratify it and vote it in. So Thomas Jefferson comes back and he goes, what the hell did you guys do? Well, this is not what we set up. And in fact, the germ of dissolution is seated within this infernal document. He says it allows the judicial branch of the federal government to work like gravity by night and by day to usurp the sovereignty of the states, which is exactly what happened. See, the biggest thing that the Constitution did, not only did it overly centralize power to the degree necessary enough for them to get their foot in the back door, the Bar Association, but also it created a federal judiciary. And that federal judiciary was used immediately after and has been used to give the illusion of validity to their unlawful enactments and executive orders and et cetera, right? So now, even if they do something that's unlawful, and we know it's unlawful and it's against the original law, the common law of this country, you go, well, the Supreme Court declared it was constitutional. Well, fuck them. Who are they? Right? That's what the Constitution did. Immediately, because we had I think it was like 8 or 9 presidents before George Washington. But once George Washington became president under the new Constitution, he immediately flexed his new executive power by squashing a tax rebellion known as Shays' Rebellion. Daniel Shay was a Revolutionary War veteran who had just, obviously killed a bunch of people and had a lot of friends and family and stuff die. And immediately after the founding of this new republic, they want to go ahead and scrap the original framework and try to create this strong federal government and then institute ridiculous taxes, which was one of the very reasons they fought the war in the first place. So he rebels, and George Washington flexes his muscle, much like we see happening today, and brings the Continental Army down there to stomp him out. And that's exactly what happened. And that set a precedent too, and it let everybody else know, now this is how things are working. So I'd say we were only the republic we were supposed to be from 1777 to 1870. Or I'm sorry, 1887 or 1787. What the hell am I talking about? 1777 to 1787. That's it. That's it. 10 years. But a lot of the vestiges of the absolute property ownership continued to linger on, and there wasn't much they could do about it because the first 2 times they established a central bank, it failed. Now, there's a big portion of this that I forgot to mention. Just like I said, all of this is the result of papal bulls and Roman trust law. When they created those companies in the 1600s, the very companies that came and colonized different portions of the world ended up becoming their governments. So the East India Trading Company became the United States. The Hudson Bay Company became Canada, so on and so forth. I'll show you something. How many of you had seen the East India Trading Company flag before? Whoops. I bet if you haven't, you're going to be surprised to see what it looks like. The East India Trading Company flag. That is definitely not it. It's this one. Oh, sorry, guys. You guys can't see. I got to share the whole window. My bad. This is the East India Trading Company flag. Does that look familiar at all to anybody here? Yeah? No? Okay. So what was the purpose of creating these companies and then establishing them as national governments? Well, the problem for them here is that it wasn't the government of a country. It was the government of a trust created by a coalition or confederation of countries, right? So each country or each state is your country, okay? Each state is your country. I'm a Michiganian. It's actually in the Oxford Styles Manual, the different nationalities. It's obviously an older Styles Manual, but it tells you these are the nationalities: Michiganian, Alabamian, you know what I mean? New Hampshireite. I didn't even know that till I read it there. And so the problem was that the company, the East India Trading Company, that became the United States, it only could govern this trust. It had to figure out how to expand itself to within all of these nations that were constituents of this trust, right? So, not to mention that, but one more thing about the Constitution, also makes you liable for the debt of the principal as well. That's what a constitutor is, but I'll get into that another time. Anyways, so the purpose of it was to eventually bring all of the people in all of the several states under this one umbrella in tandem with the central banking system, and then balloon the debt and pop it so that now all of the people being subject to this one central corporate entity would become enfranchisements of a bankrupt corporation and therefore subject to a trust indenture by being used as collateral to continue funding this bankrupt entity. Okay. So that was the purpose of the creation of all these companies, was to eventually balloon their debt and bankrupt them to enslave you. This world trust system has been in the works for centuries. Centuries. That's why I say it's almost like they knew about AI before before we even caught the first glimpses of it. Like for centuries, it seems like they knew about this power, but that's just my speculation. I can't prove that, but it definitely seems like it, because everything they've done has been in preparation has been creating a world trust system and then laying the groundwork to make it permanent via a digital prison, which is where we're at right now. That's what's taking place today. See, Penhollow v. Doan's Administrators. Let's see if I have that one pulled up. Pretty sure I do somewhere. Penhollow. Well, I can just look it up. Hold on. It's actually very important. So you'll see Penhollow v. Doan's Administrators. I see it all the time on Facebook, and be wary of these. If you see people posting memes with quotes from court cases or citations from court cases, don't just blindly use them. A lot of them are put out by intelligence assets and basically counterintelligence operations to make you look stupid, so that you humiliate yourself in court or in front of other people, and then you become disheartened and stop looking into this. So the Penhollow versus Doan's Administrators people normally see is the one that says, the government cannot attain parity with the people, for it is an artificial construct of the mind, right? While that is true, and that is the very basis of understanding that formed our original system, nowhere in this court case does it say that. And don't you wish it did? Don't you think it'd be super easy if it was already in a court case? So I hope you guys stop falling for that dumb shit. But there is some good stuff in this case, and I want to show you something. So Control F, and we will say Confederate. Yeah, that's what I search. So I do Control F. All right, Confederate. This is an important citation out of this. It says, but wherever an alliance is not corporate but confederate, the sovereignty resides in each state. Okay, that's the difference between a corporate union and confederate union. After the Organic Act of 1871, after the dissolution of our original de jure confederate framework of government during the Civil War, when it reformed afterwards, right? And this is one of the reasons why Lincoln was killed, which, I mean, he was a tyrant, but whatever. This is one of the reasons he was killed, was that he wanted to restore the southern states back to their pre-war status, and he refused to establish a central bank, so he had to go, right? And they needed the South to be subjugated because, one, they had all the resources, and two, they needed to be able to, through the Reconstruction era, set up their administrative framework via the 14th Amendment. So we are actually still a confederacy. And Confederate doesn't mean racist. Confederate doesn't mean none of that stuff, okay? Confederate is a type of union, as you can see. And it says right here, now the state retained all powers which she did not expressly surrender to the Union. A state cannot cease to be sovereign without its own act, nor can sovereignty be asserted but upon a clear title, which is obviously the Emergency Banking Relief Act destroyed all that. But all right. That's the point here. Now I'm going to prove to you that we're actually a Confederate Union. Okay. Yes. Janusz agrees. Yes, Confederation is Union. Well, it's so right here. If you don't believe me, let's see which page it is. This is an old 1846 1846 revised statutes of Michigan. Okay, that's not the right one. It's got to be this one then. Hathi Trust is a bit slow, guys, because it's all photocopies. Okay, not quite. Is it this one? Well, there's one of these revised statutes I have up, and sorry, it's an afterthought to show it. But yes, right here. Okay, now I can't highlight in this because it's a photocopy, but what it says here, this is Michigan in the appendix. This is Michigan's acknowledgement of its acceptance into the Union. Okay, and it says the interest and prosperity of the state will be greatly advanced by an immediate admission into the Union as one of its sovereignties. And the people of said state are solicitous to give to her sister states and to the world unequivocal proof of her desire to promote the tranquility and harmony of the Confederacy. Right here, if you can see my cursor, Confederacy. Now, this is in 1846. So this is well after the Constitution was ratified. And think about this, just to add on to the Constitution thing about how it's actually a subversive document, the Bill of Rights had to be amended to it. And it's thanks to Thomas Jefferson, Patrick Henry, and Thomas Paine that it was, who went around and rallied the people and said, do you not see what these people just did? If you do not get a Bill of Rights amended to this Constitution, then you will just have fought that war for absolutely no reason. And so think about the fact that it was ratified, or it was amended to the Constitution 2 years after the Constitution was ratified. They actually had to campaign to get a Bill of Rights. The wealthy elite had no intention of you retaining your sovereignty. What they wanted to do was give your sovereignty to their corporate creatures, right? Because corporations never die. That's the whole purpose of the statutes of mortmain. And corporations, so a one man can only own so much and control so much throughout his life, okay? But a corporation exists in perpetuity until it's dissolved, right? And it can have as many members in it as is required to control as much wealth and assets as they can acquire. That's it. That's the whole idea. Now they can stay at the controlling side of this entire corporate fiction and enslave you through their corporations and then pass down their positions as the heads of these corporations to their descendants. They no longer have to worry about a screw up child messing up their empire, whatever the case may be, because it's now all locked up in a corporate fiction. Right? So I hope that really makes sense. And now they're trying to make this permanent. So this last little bit of time that I'm on here, I want to go ahead and get to the current events, I think. Let me just make sure there is one more thing I want to show you real quick, if I still have it up here. No, well, anyways, it's the 1929 Michigan compiled laws, and the Magna Carta is the source of jurisdictional authority. It's listed before the Declaration of Independence and before the Constitution because, like I said, they have you enslaved under administrative law, locked in a trust, right? Held in trust as collateral for the public debt, including your body. Your sweat equity is what they borrow against. And that's why they're able to tell you what to do with all your property. Okay. And while you are in this trust position, you only have equitable rights to anything around you. And it all has to be enforced in a court of equity where the judge is God. It's slavery. And it allows the bar pirates to take the position of God, lawmaker, and judge, right? No man can actually be a judge. There's but one judge. No man can be a lawmaker. There's but one lawmaker. And they know this shit. That's why they're satanic. That's why they have turned the temple into a den of thieves. That's what the court is. If you look at it in the little 3 tiers that lead up to where the judge sits and all that stuff, the entire thing is a black magic ritual. The entire thing is. Okay? And the court is designed like a temple. The courtroom, rather. It's a temple. They got their big sigil up there, their seal, right? They got their little phallic symbol, right? The dick of Osiris that they smack on a puck. They're in a black frickin' robe, dude. For God's sakes, they're wearing a black robe. And over in England, they've got the pharaonic headdress, Pharaoh's headdress. That's not a wig. It's disguised as a wig, but that's the headdress of the pharaohs. Look at it. Just look at it. Look at how they wear it. It's the headdress of the pharaohs. So let's get into how they're trying to make this permanent and the different steps that they are taking to do so. Let me stop sharing this screen. All right, we're going to actually have to share the tab. So we see what they're doing in England, right? We see that they're old Keir Starmer, fucking weirdo that he is trying to make permanent, or is trying to make it mandatory that everyone acquire a digital ID before the end of the year. They won't be allowed to work, right? And of course, that's how they're going to get you, because they made you dependent on their corporate workhouses for survival. So, you know, if you had a trade or some sort of profession or calling by which you could honestly subsist without assistance from the corporate state, you know, outside of the corporate system, you'd be fine. But if you're stuck without skills, just working at a factory or some other mindless corporate job, and no offense, I'm not trying to be mean, but you're subject to the corporate state. You have to be, because there is not separate corporations anymore, right? These are not different businesses. They are all different tentacles of one big BlackRock Leviathan. And they absolutely intend on forcing their digital tyranny on you through their corporate Leviathan. It's very important that you have a trade or some way to survive outside of the corporate system, or you're going to be screwed. It's a perfect example is basically, you know, say somehow you're not, you know, you don't require government benefits, or say they crash the economy, which is exactly what I think they're going to do. They crash the economy because they know you won't accept the digital ID right now, but they know once you're in a breadline wrapped around the block, that you'll be more apt to accept the digital ID if it's required to get that bread and you're starving. So they're going to try to do a Great Depression 2.0 over here to try to implement this stuff. Okay. And you need to be prepared for it. So now let's say that somehow you manage to escape being subject to the Depression and impoverished, but you still work for one of these BlackRock owns corporations, or BlackRock controlled corporate businesses. Well, then they're going to be like, yeah, it's pretty fortunate you still have a job. You see all those people starving out there and in bread lines and stuff. And they'd be like, yeah, man, I'm glad that, you know, I have this good job and I'm able to, you know, escape the effects of the Depression. Be like, well, if you want to keep the job, we're implementing this new policy where you have to, you know, sign into your computer or whatever the case may be by digital ID. You clock in with your digital ID, all that. The corporations, just like the last 5 years during the COOF, right, is what we'll call it. What they couldn't directly enforce through the local, state, and federal governments because of our original framework that's still standing, what's left of it, they would enforce it through the corporations. They couldn't actually force you to wear a mask, but the business that you need to buy your groceries from could, and did. See, and that was just their beta test of seeing how this is going to, you know, how this is going to play out. So without further ado, let me share. This is what's going on. We see what's going on in England, the digital ID. And the digital ID is going to,
I feel like we've
lock you into your straw man, into that trust indenture. Okay. So what you are as a 14th Amendment citizen is you're a trustee, which is a legal fiction. Okay. That trustee has been mortgaged. Its property rights have been mortgaged, right? And it's been placed as the trustee of its own estate and chattel property of its own estate under administration. That is the legal fiction, right? Now, if they're able to set up AI governance infrastructure, which they need digital ID and digital currency for both of those things to, or for that to take place, to have any kind of like enforcement measure. They need to be able to punish you, and the AI needs to be able to see you and link all of your activity to one centralized file. That's the digital ID. And the digital currency is the enforcement measure, to shut off or reprogram the currency to restrict what you're allowed to buy or your access to travel, stuff like that, right? So they need those two things. And once the AI governance is in place, if we accept those two things, then it eliminates due process. So right now, you get pulled over, they're attempting to administer your estate. They're attempting to generate their own commercial paper, their own debt securities, because these courts are actually banks, right? And they're part of the Federal Reserve System. And they want to be able to issue their own debt currency in the form of tickets and bonds and stuff like that. They want to create debts that they can then securitize and sell to institutional investors. And they do that by fining and feeing you for the misuse of property under administration, right? So you don't follow the administrative regulations under the Federal Reserve System, such as the Motor Vehicle Code. Then they create an attachment to your trust estate or to your trust, right? Which is the Social Security. That's the public charitable trust backed by the Rothschilds and the Vatican. All your registrable properties tied to that Social Security number. And then when they create attachments through the account numbers associated with the registration, say like your plate or your driver's license number, right? Then that links directly to the Social Security trust, and they can use that as the guarantor, as the surety for their own commercial paper. Because see, all debt currency, all of our currency right now is debt securities. And debt securities, in order to have the illusion of value, must be secured by a promise, right? Must be secured by a promise to pay in some future date with some collateral. So they're able to tie it to you via the Social Security number to your trust, and then use that trust as the collateral for their own debt securities, which they then sell to institutional investors. And it's all about regulating your property and controlling you while making themselves filthy rich in the process. That's why all lawyers have an IOLTA account, interest on lawyers' trust accounts, where a portion of every case goes into that. That's their cut. That's their slice of the pie, right? So they'll eliminate due process with AI governance. Now, instead of going in the court, where right now you can go into court and say, Your Honor, is this a court of law or equity, right? And you always want to ask questions, place the burden of proof on the court. Don't make statements, because then the burden of proof is on you. But you want to say, is this a court of law or equity? Oh, it's a court of law. Okay, where's the victim? Where's the injured party? Right? One of the jurists had somebody try to say, oh, the state's the injured party. What? And then, so how is the state claiming injury against me? Because I didn't convey the right of my personal property to be used as collateral for the debt of a foreign corporation? That's not, it sounds like you're actually victimizing me. That's piracy. Okay. So you don't have the opportunity to do that with AI governance. You don't have an opportunity to trip them up. And that's why they want it so bad, because as soon as the infraction is registered by the artificial intelligence governance, the AI governance, the consequences will be immediate and automatic, right? Because it has access to your everything, right? That digital ID you need to travel, you need to access your bank account, you need to do all this different stuff in your digital currency. It's all linked together. And so say your car registers that you're speeding, bam, speeding violation, now deducting 100 credits or 100, whatever they call them, right? Digital dollars, whatever they want to call them. Boom, enforcement immediate. No ability to challenge the AI governance and say, those administrative regulations only apply to indentured 14th Amendment citizens, not to me. You don't get the opportunity to do that. And you will have forfeited it if you accept this digital ID and digital currency. You will have because somewhere in the paperwork of your consenting to this digital ID and digital currency will be a clause where you agreed to be subject to digital or AI governance. And 100, I think it was like 100 and something countries just signed on to agree to be subject to this AI governance stuff. So it's getting down to the wire. Now we see this going on in England, right? And we see this going on all across Europe. And you think, well, that'll never happen here. Check this out.
We've been warning about age verification, age assurance, and all of these things, which actually all mean digital ID coming to the United States, until we're blue in the face. And I feel like we've been screaming into the wind with not enough people paying attention to this issue. And this is, of course, not a wide condemnation of our viewers. We know that you all take this very, very seriously. But unfortunately, a lot of the population is distracted with other things while this agenda steamrolls ahead. Well, as of January next year, Texans will have to submit to age verification to use Apple and Google services. This article comes to us from...
So age verification, that's the trick. They already have that. They come, and they rightfully can come at you or come for you through your vices, right? And what I mean by that is that's historically what they've always done. They come after you in the areas where you shouldn't be doing those things in the first place, say like gambling or pornography and stuff like that, right? So, or, recreational use of drugs, stuff like that, which is pharmakia, right? They come at you through there. So already in Texas, in order to, like, say, go to an adult website, you have to do an online age verification. And how can you argue with them? This is the challenge with how can you argue with them? Because first of all, you shouldn't be doing it. And secondly, they want to make sure that kids can't do it, can't access that material. So they come from like a very defensible point, but it's really a Trojan horse. It's a Trojan horse to link your online activity, your digital activity with your identification. And it's the very first precursor. And they did it in Australia. They did it in England. It's the very first precursor to the digital ID, right? It really kind of creates a digital ID without even actually calling it a digital ID. It links your online activity to your identification. Okay. So I wonder how a VPN would fare against that. But so they already have that in Texas. To go to an adult website, you got to have age verification. But now they want to expand it, since people accepted that encroachment upon their privacy and their freedoms, right? They're going to take it to the next step. Now you have to have age verification to use Google and Apple products, because we want to make sure you're not using anything that's inappropriate for your age. See, and this is all administration. It's all treating you like you're a helpless infant pauper, right? You can't parent your kids. Your kids are actually our property because we're a party to your marriage, and therefore we're entitled to the fruits of that union, that merger between two corporate enfranchisements. We're entitled to that. And so that's your property, and we're just letting you care for it, right? But we don't trust you enough to not let it access restricted items. That's what this is really saying. That's the guise of, this is all under the doctrine of parens patriae, government as parent, which is the Roman civil law, fundamental doctrine of Roman civil law, right? Government as parent, daddy government. You don't know what's good for you, so the government's going to make sure that you do what's good for you. You're not trusted to keep your kids from accessing adult websites, so we're going to do it for you. Only in equity could they do this, because first of all, it's not even crime, but it's trying to stop something before it happened, which only law cannot recognize. That DUIs can only happen in equity, for those of you who don't know that, because it's a pre-crime. You could be, and I'm not saying I agree with people driving drunk. I don't think they should do that at all, but I also have a different definition of what drunk is than the governing so-called authorities do, right? If you have a beer at dinner, then how's that a DUI? But it is, okay? And so it's also a pre-crime, because you could have had a beer or two and be driving, and you're driving perfectly fine. You haven't harmed anybody. You get pulled over, somehow catch the scent of a beer or something, breathalyzes you and punishes you as if you did hurt somebody. You did nothing. That can only happen in equity. The law does not recognize, like an injunction. An injunction is something in equity that stops somebody from doing something in the future. There's no such thing as an injunction at law. Common law has no such concept, because common law only deals with what exists in fact, what has happened. Who exists in fact, not an artificial construct of the mind, not a legal fiction. That's why that has to be adjudicated in equity. All trusts have to be adjudicated in equity, because the law does not recognize trust. It recognizes the validity of the trust, but it has no prescription to enforce the trust, because no terms of the trust are actually law. They're just arbitrary regulations created by the beneficial proprietor, or AKA owner of the property. And so to enforce those arbitrary rules, you must go to a jurisdiction of fantasy land, which is the best way to look at equity. It's a jurisdiction of fantasy land. We're going to stop things from happening in the future, and we're going to deal with things that don't actually exist in fact. That's it, right? It can only happen. So this is another version of that, and it can only happen in equity. I seen somebody in the chat said, what are we going to do about it? Start fighting equity, start fighting the trust, start fighting the validity of the 14th Amendment. Or if you're not in the United States and you're in another country like England, Canada, Australia, you need to go through your government, your country's citizenship framework and find out where they gained the ability to mortgage you. They had to take you under administration somewhere. And that is where you have to fight them and the validity of it. Because the people originally, the government had no power of attorney to mortgage their property, had no administrative authority to do anything like that or tell them what to do with their property at all. Because as I showed earlier in the stream, all lands in the United States are, so I didn't explain that. Even though that was Wisconsin state constitution, all the states are on equal footing. So the rights the people of one state have are the same rights as the people of every other state, no matter when they were admitted into the union. And that's been upheld. So just because Wisconsin says lands are allodial, that means every single land, all lands are allodial. And they would have to be, because if the people are the sovereignty, who could have a superior claim to the land when somebody owns it? Nobody. Chisholm v. Georgia, just like I showed you guys. So this is a pre-crime. Your child might look at something inappropriate. We don't trust you to be a parent. So, or I hate that word, parent, father or mother. So we're going to go ahead and step in and force you to subject your privacy to the authority of the corporate state in order to make sure that doesn't happen. Fuck off. Excuse my language, but I can't stand these people, right?
Reclaimthenet.org, Google and Apple to enforce age verification in Texas starting in 2026. It says that tech giants Apple and Google have confirmed they will comply with Texas' newly passed age verification law, but both companies warn that doing so will come at the cost of user privacy. The legislation, known as SB 2420, is scheduled to take.
And that's lip service. They warn, hey, if you guys do this, it's going to cost our users their privacy, as if they're not all in on it together.
Take effect on 1st of January 2026. Scumbags. Under this law, app marketplaces and developers will be required to implement strict age assurance mechanisms that, according to Apple, will force the collection of personal data even for basic app downloads. Beginning January 1st, 2026, a new state law in Texas, SB 2420, introduces.
Yeah, Yanush brings up a good point. Texas, so many arms, right? Because we're on YouTube as well. And people do not do what they should. Hopefully when push comes to shove, they will. But, we'll see. Because what they do is they keep everybody complacent and comfortable in their artificial womb of society. And then they're just going to pull the rug out all at once. And it's going to be interesting to see how many people submit and how many people do not submit.
Age assurance requirements for app marketplaces and developers, Apple stated in a developer update. While we share the goal of strengthening kids' online safety, we are concerned that SB 2420 impacts the privacy of users by requiring the collection of sensitive, personally identifiable information to download any app, even if a user simply wants to check the.
See, and that taking the 14th Amendment citizen, please realize it's not just the bankruptcy. It's not just the Emergency Banking Act and the mortgage of your estate that places you under administration. That cements it and gives foreign third-party money interests a portion of that administration, right? An interest in that administration, which is really screwed up. And that's how ultimately, the Vatican, the papacy, and the crown are able to control you from all the way overseas and everything, as it trickles down through the bar association into these administrative agencies, and then boom, to you, controlling your property, right? But just the very nature of the 14th Amendment citizenship itself is it's under administration, because they offer one of the responsibilities of someone who's under administration, right? Or one of the responsibilities of the administrator, and this is right out of the Magna Carta, is essentially to protect and to preserve all of the property that is under administration, right? They have to. And so this opens the door and allows them, in the name of protecting you, to take more and more of your liberties. And so you have to look at it like this. The states of emergency to the people, they could never, the original people of the states, they could never issue a state of emergency and then subject the people to it. Never. They'd be like, fuck you. We don't care if there's an emergency. We take care of ourselves. We protect our own rights. You're just a utility. You do the things that we don't want to be troubled with every day. That's it. So no state of emergency. They could have issued a state of emergency and that would have only applied to government employees. And the people would just be like, and so, right? But once you're under their administration via the 14th Amendment and they're governing you through the doctrine of parens patriae, or government as parent, now protection becomes their tantamount duty, right? And so they engineer these emergencies in order to, in the name of protecting you, further their agenda of enslaving you. That's what 9/11 was about. That's what every day, you think about it, all throughout history, they do that over and over and over again. Before they even passed the Set to KV Act, they burned London to the ground. And that was right after a massive plague. So you're talking about killing 70,000 people. People were scared, and the government's like, here, we got to protect the interests of the lessees and revisioners. And so if people are, until you claim your estate, it's going to be under the administration of the crown. Same thing here, look at the things that got us pulled into world wars and what resulted from that. The banking emergency was the justification for mortgaging your estate. Be like, listen, this is an extraordinary situation. Our duty is to protect you because you're under our administration now that you're a 14th Amendment infant pauper. So we have to mortgage your estate to the third party, central banking cartel in order to continue our existence. And another thing about the 14th Amendment is, think about it like this. The people created the states, and that's why they're above the states. They are the creators, and the creator is never subject to the creature. Then the states got together and created the federal government, okay? And the states were above the federal government, as we've seen in the first 10 amendments, the 10th Amendment, right? That the state retains all powers which she did not expressly give to the federal government via the Constitution. So anything that's not stated in there that the government can do, the federal government can do, they cannot do. That's the operating understanding of how that works, right? And any judge who's honest, right, especially Supreme Court judges, and many of them have said this, they'll admit that, right? So you got the people created the states created the federal government. So the federal government's subject to the states subject to the people as creator, right? So what did the federal government do? It created its own creature called the 14th Amendment citizen. And now that creature exists entirely at the mercy of the federal corporation. It owes, much like man owes his existence to God, to the creator, and must necessarily be subject to God's will. The 14th Amendment citizen owes its existence entirely to the federal corporation and must be subject to its will. Right? So it's a very important concept to understand of why they created that class of citizen. And now, because that 14th Amendment citizen is essentially a child of the federal corporation, no matter how old you are, and I'm going to prove it in just a second, they can justify basically telling it what to do, selling its property rights, doing all these different things in the name of protecting it and for its benefit. And again, I can't stress this enough. That's why Title 42, as I'll show you once again, if you're just now joining the stream, that's why the space program, and many of you know the truth about space and about, where we live and stuff. I don't really go into it on this channel, but we all know that we're not spinning, at impossible speeds in 4 different directions, hurtling through a vast expanse of nothingness. And it's interesting. Look, Title 42, public health and welfare. That's how they created the space program. That's where they had to put it. National Space Program. Why? Because when they're appropriating, as they call it, money from the central banking system through their budget proposals, it has to be presented as if it's for the benefit of the infants under administration. So every line begins with, Congress declares that the general welfare has to be welfare. And they do mean welfare, right? Congress declares that the general welfare, right? And it goes on and on and on. So Every single one of these new sections start with Congress declares the general welfare. And the reason being is because it has to be presented as if it's for your benefit. So with that being said, I'm going to show you guys. Oh, and let me explain while I'm pulling this up. Let me explain to you the situation we're in right now and why I believe we are going to witness the collapse of the economy this year. Is because this government shutdown. So government shutdown is this elusive thing for people. I don't think people really understand because they don't realize how the economy is set up in the first place based upon the mortgage of your estate, as I've been teaching you guys throughout this stream. So every year in October, at the end of the fiscal year, the government has to get together and agree on a budget proposal. This budget proposal is basically a loan application, right, to the central banking cartel to fund them for the next year till next October, all the things that they're going to want money for to spend on and all that stuff. And all of it has to be presented as if it's for your benefit. Okay. And when they can't agree on the proposal in time, the government shuts down because it's bankrupt. It can't exist without continuing its existence via loan applications, aka budget proposals, right? So they disguise it by calling it a budget proposal, but really they're just setting out what they're going to appropriate money for, and then they submit that to the central banking cartel and they get their funding. And it's all based on the mortgage of your estate. Now check this out. The word person, so this is Title 1, Section 8, and you guys have to know with statutory construction. So before I even go into this, statutory construction, right, is when they can, before they actually write the enactment, they list all of the definitions for all the words that are going to be used in the enactment. And they can put whatever definition they want in there. And it means only for, it means only this for these purposes in this enactment. And then they'll specify it doesn't mean this in another enactment, blah, blah, blah. So this is part of the statutory construction of the entire United States Code. Okay. And the word include, you have to understand what the word include means. Include is at the exclusion of everything else, unless otherwise stated. To include is to contain, to box in, to make only this. So if I say, different cars, or the word car includes Volkswagens and Audis, right? That means anytime I use the word automobile, I'm either talking about a Volkswagen or an Audi. Now, if I say the word automobile includes but is not limited to Volkswagens and Audis, now when I use the word automobile, it just means any automobile, because I said includes but not limited to. Without that but not limited to, which is why that phrase exists, then whatever they say includes, right, it means only this. Now, with that understanding, I want you to read this. In determining the meaning of any act of Congress, any act, so that's all enactments. This is the meaning of these words, okay? Any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus, there's the administrative agencies that have regulatory policy, and agencies of the United States, the words person, human being, child, and individual shall include, which means only this, shall include every infant member of the species Homo sapiens who is born alive at any stage of development. So that means you can be a 50-year-old infant. If you're a person, human being, child, or individual, you are an infant. This makes now, who does the U.S. Code apply to? Well, only 14th Amendment citizens. And that's why I call 14th Amendment citizens infants. The way that they consider you an infant, and they also call you a minor in the Code of Federal Regulations, right? Because you've never claimed your minor account. And so it says a minor is someone who is under the age of 18 or someone who has not claimed their minor account. So you're an infant. Literally, you're under wardship of daddy government, the corporate United States, right? So when they say, when people say, if you're a 14th Amendment citizen, then technically Trump is your daddy. That's just how it works, right? Which is not cool. at all. That's why I'm not a 14th Amendment citizen. No other man except for my actual father is my daddy. And I definitely don't need the government to tell me what to do, to protect me, to offer me benefits. I need nothing that it has to offer, right? That's why I claim my estate on the record. And quite a few people have, actually. So the only other channel that I've seen that has this information is Vocational Science of Freedom. If you guys have never checked them out, go check them out. Okay. Zen is knowledgeable and how to claim your estate and the whole process as well. And other than his channel, I don't think I've seen anybody actually figure out through the history of law how they've taken us under administration as wards and infants. I have never seen anybody else. And this is so important. So if you guys really understand this, this is where we need to be looking, focusing, and we need to fight the 14th Amendment citizenship. I remember when Trump was running for president, they're like, oh, we're going to get him with the insurrection and rebellion clause of the 14th Amendment. I'm like, please bring up the 14th Amendment. Please do. Right? Because we can talk about how invalid the 14th Amendment is. So last thing I'm going to show you guys real quick, and I think you'll appreciate this. And if you guys have never seen it, it is right here. Pull it up. Bam. This is House Congressional Record. And if you guys haven't noticed, this channel is very proud of the fact that we give you all authoritative sources. If I tell you something is a theory, then I'll tell you, hey, this is a theory. I can't prove it. But if it's a fact and I can prove it, I do prove it, so that you never have to question the information that I'm giving you. Okay? Only authoritative sources, only facts, right? Well, sometimes I present theories, but I tell you, I disclose, hey, this is my theory, can't prove it. You make up your own mind on that. But this is a fact, that the 14th Amendment was never lawfully ratified. This is House Congressional Record, June 13th, 1967, page 15641. Okay. Oops. 641 right here. And it says, the 14th Amendment, equal protection law or tool of usurpation. Okay. And they go through and they talk about how the 14th Amendment was disguised as an equal protection law to grant civil rights, right, which are just privileges and immunities to the newly freed African Americans, which they didn't need them anyway, because like Johnson said, in time, they could have learned to be free. And they go through and they delineate how this was a tool of usurpation. Okay, it says the 14th Amendment's unconstitutional. It says the 14th Amendment of the purported 14th Amendment of the United States Constitution is and should be held to be ineffective, invalid, null, void, and unconstitutional for the following reasons. The joint resolution proposing said amendment was not submitted to or adopted by a constitutional Congress. That's a fact. Not only did Congress adjourn sine die, but actually, I think it's 16 out of the then 37 states rejected it. And then the United States Corporation didn't take that for, as an answer and went down and had them ratify it at gunpoint. So it says the joint resolution was not submitted to the president for his approval. Article 1, Section 7 says, and the president vetoed it anyways. Andrew Johnson's veto message is in this congressional record, right? So this is after Lincoln was assassinated and Johnson vetoed both the Civil Rights Act and the 14th Amendment, because the Civil Rights Act was what actually created the United States citizenship. And you want evidence of the complicit nature of the states and all of this is that all of the states began voter registration and birth certification requirements at the same time, because prior to the 1860s in this republic, the only thing that you had to do to verify someone was who they said they were was have their name in a family Bible. So when your child was born, you wrote their name in the family Bible. Nobody's business. Nobody had the privilege of knowing that or had a right to know the child's name unless that, child grew up and committed a crime. That's the only time they could get your, who you are. And when it came to proving who you were, right, all you had to do is have somebody attest to it or show the family Bible. That's it. So, in court, you could do an affidavit of truth and you could have, 4 witnesses verify this guy is who he says he is. He was born here, et cetera, et cetera. Boom, that's it. Not only that, but there actually wasn't such a big stink about inhabitants versus citizens. You could still have all your common law property rights as an inhabitant, right? You didn't have to necessarily participate in government as a citizen. So anyways, which really makes the whole current immigration thing quite interesting when you look at it through that lens. So it says the unconstitutional Congress. It says Article 1, Section 3, the Senate of the United States shall be composed of 2 senators from each state, right? Article 5 provides no state without its consent shall be deprived of its equal suffrage in Senate. And it says the fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for the adoption of the joint resolution proposing the 14th Amendment is shown by resolutions of protest adopted by the following state legislatures. And look, it's not even just so they'd be like, well, the southern states were in rebellion. Well, first of all, the southern states were allowed into the ratification for the 13th Amendment, the second 13th Amendment, because the original one forbade attorneys from being citizens, well, any title of nobility. But that mysteriously just disappeared from the Constitution. This 13th Amendment, all the states were allowed to ratify the 13th Amendment. And of course they did, because they're like, yeah, no, slavery's wrong. We're not with that. Cool. So they ratified that, but then we were like, oh, we're not doing this. We're not giving that kind of control to the federal corporation with the 14th Amendment. Then they just excluded them and said they were in open rebellion. Doesn't make sense. And on top of that, you'll notice one of the states that did a letter of protest is not even it wasn't even a southern state. It's New Jersey. New Jersey legislator by resolution of March 27th, 1868 protested as follows. It says the said proposed amendment not having yet received the assent of 3/4 of the states, which is necessary to make it valid, the natural and constitutional right of this state to withdraw its assent is undeniable. Right? That it being necessary by the Constitution that every amendment to the same should be proposed by 2/3 of both houses of Congress, the authors of the said proposition for the purpose of securing the assent of the requisite majority determined to and did exclude from the said 2 houses 80 representatives from 11 states of the Union upon the pretense that there were no such states in the Union. But finding that 2/3 of the remainder of the said houses could not be brought to assent to the said proposition, they deliberately formed and carried out the design of mutilating the integrity of the United States Senate, and without any pretext or justification other than the possession of power, without the right and in palpable violation of the Constitution, ejected a number of their own body representing the state, and thus practically denied to New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of 2/3 of the said houses. So, boom. And look at this. Okay, so it wasn't 16, it was 15 out of the then 37 states rejected the proposed 14th Amendment. They could all see what they were doing. This was going to allow the federal corporation to convert the citizenry of all the states to federal citizens and then gradually put state citizenship into disuse, effectively usurping the sovereignty of the state, because the state was only sovereign because its people were sovereign. A state is actually the composition of its people. It's not the government, right? And so once they did that, and it was easy for them to just put state citizenship into disuse. And now there's only federal residents of every state, and the state technically has no citizenry. And therefore, because of Article 4, Section 2 or 3, I want to say, the Constitution, it says that the Congress can make all needful rules regarding federal property within the states. Well, that includes the chattel property known as the 14th Amendment. And that's how they were able to erect federal jurisdiction within the states. It's not technically erected within the states, right? But it is in fact erected within the states because all of the people of all of the states are now federal citizens, not state citizens. So it's quite crafty, right? So all of these, and these weren't all just southern states that rejected this. You got, of course, Texas, Florida, Georgia, Alabama, North Carolina, blah, blah, blah. But you also have New Jersey, right? You have Delaware, you have Maryland, right? And you have Ohio. Those are all northern states. So it wasn't even about North versus South. It was about literally the destruction of the Confederacy. Okay. And Andrew Johnson issued a veto message right here. It says, if ever the American citizen should be left to the free exercise of his own judgment, what the hell's going on there? Yeah, we're not doing no AI stuff there, bud. All right. Now, where the hell's my cursor at? Oh, it's over here. All right. Sorry about that, guys. If ever the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he is to live. Right? That work is his work, and it cannot properly be taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution except as may be arbitrarily dictated by Congress and formed under the restraint of military rule. So that is how the federal corporation, the corporation that used to be the East India Trading Company, right, then became the United States, and its job was to figure out how to bring all the people and all the states under its umbrella and then bankrupt itself through the private central banking system in order to create this trust indenture system. It's been a concerted and deliberate plan for a long, long time. And the ultimate goal is communism, because what is communism? It's perfected feudalism. Right? That's the end goal of feudalism. Communism is central government control of all property and labor, including the citizenry. Right? So that it can redistribute whatever it wants from one person to another. It can take from you and give to him. It can take from him and give to you. But usually what happens is it takes from everyone and gives to itself. That's what communism is, and that's perfected feudalism. And the only way to set up communism is by creating a massive national trust. And that's why Karl Marx said that the central bank is absolutely essential to the establishment of communism, because you have to have that private third-party financial institution to borrow from when you collateralize all of your citizenry. And that creates a trust, and it places their own bodies in trust. Everything, because it's their property rights. And the law of mortgage entitles them to the rents and profits of the estate that has been mortgaged while the loan is outstanding. And that takes the form of revenue codes, property taxes, and income taxes. It's all part of the Federal Reserve System. And it was all very much deliberate. Very, very, very much deliberate. And now the final step is this digital ID. So with that, I'm going to shut this down. But guys, hopefully now you have a better understanding. Well, I guess I can give the summary of its liberation from, they're seeking freedom. They're seeking freedom from God's law. They want to become God. They want to lock you in equity where they get to act as God. And they want to create a world trust, which is a counterfeit system, right? It's basically they want to turn the entire world into a legal fiction outside of God's jurisdiction, where they get to be the God. And because I know that's true, and hopefully you do by now as well, because I've just spent the last 2.5 hours showing you with authoritative sources and treaties and whatnot. I do view the combination of the digital ID, the digital currency, and the AI governance as the beast system, the mark. It has to be, because that's what's going to permanently lock you into trust indenture and forever bar you from accessing the law that the creator has woven all throughout this creation. And the crazy thing about this is their real goal. This is why you got to look at it in its entirety, because the law is the primary point, right? This is absolutely why all conspiracies converge into this right here, what they're doing with the law to set up worldwide communism. Okay. One of the aspects of that is genetic modification. When they genetically modify something, it no longer is a creature of the Almighty. It is a creature of whatever corporate entity patented the modification, right? So when you have unalienable rights endowed upon you by your creator, well, if the creator is no longer technically your creator, you become something else differently entirely, well, then I guess the privileges and immunities are going to be granted by your corporate creator. So the genetic modification aspect is a big part of this as well. That's why they're trying to change nature, genetically modify insects and animals and all these things, because eventually what they want to do is they want to eradicate the original creation, right? And live in a world of their making where they get to be God. That's where we're heading, guys. So with that, yeah, so like Janusz says about the jab, exactly. With that, I'm going to shut this down. I appreciate all of you for watching. Hopefully, I got you to see where I'm coming from and what I'm saying. What they're doing, I prove. I've proven to you throughout this stream. So this is what they're doing. This is how they're doing it. What their ultimate goal is, however, still remains to be speculation. I just shared my speculation with you. I think they're trying to annihilate the original creation and live in a world of their own creation, modified creation. You know, it's not, they don't create anything, just modify what the creator made. But that's what the devil does, right? So it's truly satanic. These people do worship Satan 100%. And I do believe that's where they're getting this knowledge. So I hope you guys enjoyed the stream. I hope you were able to learn some stuff, and please leave comments. I know I didn't address the chat too much throughout the stream, but this was a lot of dense information that I needed to get through, and I didn't want to detract from the flow of linking everything together in a fluent fashion for those who may not know these things. So next time I will focus on the chat more for sure, and leave a comment. Let me know what you guys think or what your opinions are, and I will get to them and respond to them as soon as I possibly can. So you guys have an excellent day, and I'll see you very soon. Later.